this edition of Practical Probate, I'm going to take a look at some common probate misconceptions for Connecticut probate. I'm Dom Calabrese. Since 1995, I've been a Connecticut attorney, and since 2003, I've been a Connecticut probate judge. The purpose of this video is to give you some information on probate misconceptions in Connecticut. It's not intended to be, nor should it be relied upon as legal advice. For information and advice as to your own particular situation, you should consult a qualified attorney. So let's look at some common probate misconceptions. One of the misconceptions is that if the decedent's assets are in a trust, in Connecticut, when that decedent passed away, there's no need to go to the probate court. However, that's not true. In Connecticut, when a decedent passes away, the assets in the trust are still subject to Connecticut estate tax and Connecticut probate fees. If there's any real property that was in the trust or the decedent had any interest in Connecticut real property, then probate proceedings for a tax purposes only estate will be necessary. Another misconception is that a living trust is a substitute for a will. I hear that often. Do I need a will? Do I need a trust? A trust is a substitute for a will. Well, there's a caveat to that. A living trust is a substitute for a will, but only if the living trust is funded during the lifetime of the person who created it. So whatever is in that living trust, when the person who created the trust passes away, that will pass outside the probate process. But unfortunately, I see many situations where people create living trusts and they never fund them. So oftentimes people come into the probate court, either the widow or widower or the other surviving family members, and they show that the decedent had a living trust, but they never put assets into it. So at least for the purposes of avoiding probate, an unfunded trust is going to have absolutely no use whatsoever. Another misconception is that in Connecticut, someone can simply write down what they want to happen with their assets when they pass away, and that will be sufficient to function as a will. And in Connecticut, that's not true. That's called a holographic will. And in Connecticut, holographic wills are not recognized. That may be the case in other states as well. There are certain formalities that have to be followed when someone prepares and executes a will. And if those are not carefully followed, that document that someone might have believed to be their will not be effective as a will. Another misconception is that if someone passes away without a will and they're married, everything they own is going to go to their spouse automatically. And that's not the case at all. In Connecticut and all other states, when someone passes away without a will, the laws of that state govern which of their relatives gets their assets, their solely owned assets, that is. So, for example, in Connecticut, if someone passes away without a will and they're married with children, their surviving spouse would get the first $100,000 of the probate estate, and then everything above $100,000 would go 1/2 to the surviving spouse and 1/2 in equal shares to the surviving children. However, if one or more of the surviving children is not also the child of the surviving spouse, that mechanism changes. So in a situation where maybe you have a second marriage, instead of the outline that I gave you for distribution, all of the decedent's assets are divided in half. Half go to the surviving spouse and half go to the children or representatives of them in equal shares. Another misconception is people putting their final arrangements in a will. For example, their burial arrangements, their funeral arrangements. And while technically that's not an incorrect thing to do, if you think about how a will operates, by the time the will is admitted to the probate court, someone has passed away at least several weeks, and in some cases, several months. So those arrangements in the will are really not going to have any legal effect at that point. And another misconception is that a will has effect while someone is alive or after someone passes away, but that's really not true. In order for a will to have legal authority, it must be admitted to the probate court or the appropriate court in that particular state where the decedent passed away. And if it's not admitted to the probate court, that will has no legal authority whatsoever. And when someone's final arrangements need to be made immediately upon death, that admission of a will, if there was one to the probate court, is still some distance away. So I recommend, in terms of providing for your final arrangements, a better approach is either to do a prepaid funeral or to let your loved ones know what your wishes are. Another misconception I often hear is someone telling me that they're the executor of the estate of someone who's still alive. They might be named in the will to be executor, but no one is an executor unless and until the person whose will names them executor passes away, the will is admitted to the probate court, and the person named in the will as executor is appointed by the court. In the absence of a court appointment, no one is an executor. Many people believe that a will can somehow help provide for the management of their affairs and assets if they become incapacitated. And that's absolutely not true. A will has no utility whatsoever until someone passes away and that will is admitted to the probate court. It's very important to plan for incapacity, but a will is only effective after someone passes away, so it has absolutely no use while someone is alive. Another misconception that I believe is very widely held is that an executor who's appointed by the probate court, or if someone passes away without a will, an administrator, may do whatever they please with the estate. And that's not true. An executor only has the authority that the will says they have, and anything beyond what is in that will as far as their authority must be permitted by specific decree of the probate court. An administrator is someone who's appointed by the probate court for someone who passes away without a will. The only authority an administrator has is to protect and marshal the assets of the deceased person. Anything else they may want to do, sell real estate, transfer funds, take legal action, requires the approval of the probate court. And one of the reasons why we have probate courts is to give everybody interested in the estate the opportunity to come before the judge and let the judge know if they want the administrator or executor to be given permission for whatever it is they may be asking. A fiduciary duty, which is the duty that an executor or administrator must follow, is among the highest standard in our entire United States legal system. They can't engage in self-dealing, and they have to follow the law. I have a separate presentation in which I'm going to be talking about fiduciary liability because it's a very extensive area. Many people believe that a power of attorney is effective even after someone passes away. And that's also a misconception. Once the person who grants the power of attorney passes away, the authority of the agent under that power of attorney automatically terminates by operation of law. In fact, if someone continues to act as an agent under a power of attorney, knowing that the grantor passed away, that person is subject to civil and criminal liability. A question and a misconception I often hear of is if someone moves from one state to another, in this case I am a Connecticut attorney and probate judge, so we'll focus on Connecticut. If someone moves to Connecticut from another state and they had a will prepared in their previous state, they need to have a new one prepared upon moving to Connecticut. And that's not true. In Connecticut, a will that is prepared and executed that fulfills all of the legal requirements of the state where it was executed will also be honored in Connecticut. Now, that's not to say that it's a bad idea to review your estate plan when you move to a new state. I think that's a great idea. I think whenever you have a significant change in your life circumstances, that's a time to meet with an estate planning attorney to review your estate plan and to update it according to your changing circumstances or changes in the law. Another misconception is that a photocopy of a will may be admitted to the probate court without extra proceedings. Only the original will has legal authority. A photocopy of a will does not have that legal authority, and it will not be admitted to a Connecticut probate court without additional legal proceedings. So it's important to maintain a secure location for an original will, and also to let your loved ones know where that original will is stored so it can be located if it's needed. Out-of-state real property is not under the jurisdiction of the court. So any court, any state court, particularly the probate courts, only has jurisdiction over things that are located within that state. And that's certainly true for real property. So if someone who's a Connecticut resident passes away and they own real property in another state, there will need to be ancillary probate proceedings in the other state to determine what happens to the real property that's located outside of the probate court state.